A developing story tonight. Convicted murderer Oscar Pistorius has been eligible for parole for 6 months already. That's been confirmed by the Constitutional Court. It found that he served half of his term, or had served half of his term, by March this year. Pistorius is still in custody for the 2013 Valentine's Day killing of his then-girlfriend Riva Steenkamp. Journalist Karyn Maughan has been tracking this story from a decade ago and has been also watching the latest on the developments from the courts. Karyn, a very good evening to you. Thank you so much for your time. So what does this mean in reality for Oscar Pistorius?
Well, essentially what it means, Tembekile, is that his parole hearing, which he was supposed to have finalized in March this year, after the 21st of March, which is when the Apex Court has now said he became eligible for parole, must be finalized by the Correctional Services Department. It's important to stress that this does not mean being eligible for parole does not necessarily mean that you'll be granted it, but we know that at the time that Pistorius was denied parole in March this year, the ECS explicitly said that it was solely on the basis that he hadn't completed that minimum detention period, i.e. half his sentence. We now know that the Constitutional Court has found effectively that at that time he had considered parole, he had become eligible for parole by serving half his sentence, and therefore we should expect that the parole authorities will be hard-pressed not to release him at this point.
And Karyn, why has the calculation of what should be basic mathematics when it comes to the parole of inmates, why has it been such a mess in Oscar Pistorius' case? Because many of us will remember when the media went to the Correctional Services facility where he was kept, where the hearing was due to happen, and when we got there, we were simply told that it would no longer be happening because the calculations were not done properly.
I think there are a lot of very far-reaching questions that need to be asked at this point, not least of all was the role played by the Supreme Court of Appeal in this. We know that after the court issued its sentencing judgment in which it found that he should get 13 years, 5 months for Riva Steenkamp's murder under the principle of dolus eventualis, the court in January 2021 issued an order saying that that ruling it was obvious, it said, should have been antedated to the 6th of July 2016, which is, of course, when Pistorius began serving that first 6-year murder sentence for the killing of Riva Steenkamp. Now, that order was recanted under very mysterious circumstances that up until this point, no one from the Office of the Chief Justice has been able to explain to me. And effectively what happened was that 3 days before Pistorius' parole hearing was due to take place, the Chief Registrar of the SCA sent a letter and effectively said, well, you know, the sentence only came into effect in November 2017, effectively discounting a year and 4 months that Pistorius had already served for that first murder sentence. So this is what has now prompted this litigation, and it was clearly something that vexed the Constitutional Court, because when they agreed potentially to hear this matter, their crucial question to Pistorius, to the correctional services authorities were, what are the effects of these orders, and can they be said to have been legally recanted by these letters? What are the legal status of the letters? Now, because this case has not been heard, those issues haven't been fully canvassed, but I think there are some real questions about how this happened in circumstances where arguably the SCA potentially added, 6 months to his term behind bars before he became, eligible for parole, when in fact he was eligible in March already.
And could there be consequences for the authorities when it comes to such a serious miscalculation, it seems?
I think that there needs to be questions, because court orders are very important. A ruling by the court is a significant, something that any human being will want to comply with. And I think that, there are also question marks as to why Correctional Services was constantly sending these various letters to the SCA in relation to Pistorius' sentence when those orders were already in existence. I must say that there was an order a wrong order that was granted in relation to when his sentence came into effect, that both he and the Correctional Services authorities have admitted was incorrect. But certainly that first order that was granted was right. It wasn't recanted by a formal court process. And it really is deeply concerning that a simple letter sent by the registrar would essentially have the effect of prolonging someone's jail term. Because if that thing had stood, he would have effectively, on the proposition put forward in that letter, only become eligible for parole in August 2024, and effectively in those circumstances have received a 16-year, 4-month sentence. I think that's very serious, and regardless of how people may feel towards people convicted of serious crime, there needs to be a long, hard look at how this happened, and assurance is given that it can't happen again.
And in Pistorius' case, lastly, Karyn, as you said earlier, being eligible for parole does not automatically mean that one will be granted parole. What are the obstacles to him being granted parole at this stage?
Well, my understanding is that, I've read the psychologist, social worker, all his prison authorities, they're all totally in support of him being granted for parole. Of course, we know that Reeva Steenkamp's parents, the late Barry Steenkamp and June Steenkamp, have expressed the viewpoint that they do not want him to be released, that they don't believe that he has told the full truth of what has happened. But their input has been obtained by correctional services and in itself is not a barrier towards him being granted parole. And certainly from the perspective of the Steenkamps, their lawyer telling me today that they had actually believed that he became eligible for parole in March, and that they thought the Constitutional Court in this instance had done the right thing.
Karyn Maughan, good to speak to you, journalist, updating us on the latest around Oscar Pistorius, the Constitutional Court confirming he was in fact eligible for parole.